They told us paper was just for writing. They didn't tell us it was for building. Welcome back to the archives of the pivot paper. I've got a story for you today about a woman who had to redraw her own map. Her name was Margaret, 53 years old in 2015, a bookkeeper by trade, a mother by biology, a bank account by accident. She didn't know that last part until the letter came. It arrived on a Tuesday, cream-colored envelope, law firm return address, the kind of paper that feels expensive even before you open it. Inside, a summons. Her daughter's divorce attorney was coming after Margaret's retirement savings, not because Margaret owed anyone anything, but because her name was on her daughter's checking account, and in North Carolina, joint ownership means joint liability. Margaret had put her name on that account 4 years earlier. Her daughter asked, said it was just for emergencies, so if something happened, Margaret could help with the grandkids. It seemed reasonable. It seemed like what mothers do. What Margaret didn't know, what no one had told her, was that joint owner doesn't mean helper. It means co-debtor. It means her daughter's creditors could reach into Margaret's account. Her daughter's ex-husband's attorneys could attach Margaret's wages. Her daughter's bankruptcy could become Margaret's bankruptcy. The law doesn't care about intention, it cares about signature. That night, Margaret sat at her kitchen table with 3 bank statements spread in front of her. Checking account at Wells Fargo, Margaret's name listed second under her daughter Simone. Savings account at B&T, Margaret's name listed second under her son Marcus. Emergency fund at First Citizens, Margaret's name listed second under her youngest, Terrence. She had done this for all 3 of them because they asked, because she thought it was safe, because she believed that being listed second meant she wasn't really responsible. The rain outside her window was the same rain that had been falling all week, spring in Durham, everything wet, everything waiting. Margaret traced her finger across the paper, her name right there in black ink, but somehow invisible. She had spent 31 years building that retirement account, 31 years of automatic deposits, modest contributions, compound interest doing its quiet work, $73,000. Not a fortune, but enough to stop working at 65, enough to not be a burden, enough to leave something small for the grandchildren when she was gone. And now it could all disappear because of someone else's divorce. Margaret's grandmother used to say, "Baby, don't co-sign nothing you can't afford to lose." But Margaret hadn't co-signed alone. She had just helped. At least that's what she thought. The attorney's letter said the court could freeze her accounts pending the divorce settlement, that her portion of the marital estate, which included any jointly held assets, was subject to equitable distribution. Margaret read that line 4 times. Marital estate. She wasn't married to her daughter's husband. She had never even liked him. But the law said her money was in play because her name was on the paper. That night, Margaret couldn't sleep. She kept thinking about all the years she had worked, the weekends she picked up extra shifts, the vacations she never took, the new car she never bought, all of it sitting in an account with her name in the wrong position. She thought about her mother, gone now 7 years, who had cleaned houses her whole life and died with nothing but a paid-off mobile home and a shoebox of cash under the bed. Margaret had promised herself she would do better. She had promised herself she would leave something official, something documented, something that couldn't be lost or stolen or claimed by someone who didn't earn it. But here she was, 53 years old, a joint owner holder in her own retirement. The next morning, Margaret called the bank. She asked how to remove her name from her children's accounts. The representative said, "Ma'am, you can't remove yourself. You're a joint owner. Both parties have to agree. And even then, it's easier to just close the account and open a new one." Margaret asked what happened to her money if the account was frozen. The representative paused, then said, "If there's a court order, we have to comply. Joint ownership means joint exposure." Margaret thanked her, hung up, and sat very still. She had spent decades teaching her children to save, to build credit, to ask for help when they needed it, and now that help was going to cost her everything. But Margaret was a bookkeeper. She understood ledgers. She understood the difference between assets and liabilities. She understood that every name on a page carries weight, and sometimes that weight can crush you. What she didn't understand yet, what she was about to learn, was that there was a different kind of paper, a paper that could rebuild the walls around her money, a paper that could make her name mean owner, not guest. Margaret didn't know it yet, but she was about to meet a woman who would show her the architecture. To be continued. Margaret found the estate attorney the way most people found salvation in 2015, through a friend who knew a friend who had survived something similar. The attorney's name was Diane Holloway, black woman, late 50s, office in a converted Victorian near downtown Durham, the kind of place where the floors creaked and the bookshelves were older than most of the clients. Diane didn't offer platitudes. She offered structure. Margaret brought everything to that first meeting, all 3 bank statements, the summons, a yellow legal pad where she had written down every question she could think of at 3 in the morning. Diane spread the statements across her desk like evidence at a crime scene. Then she asked one question. "Did anyone ever explain to you the difference between access and ownership?" Margaret shook her head. Diane leaned back in her chair. The leather made a sound like an old hymnal closing. "Access means you can see the money, you can deposit, you can withdraw if necessary, but you don't own it, and you're not responsible for it." She tapped the first statement with her pen. "Ownership means your name is on the title. The creditors can come for it. The courts can freeze it. The IRS can levy it. You're not helping anymore, Margaret. You're liable." Margaret felt something shift in her chest. Not panic, clarity. Diane pulled out a leather portfolio and opened it to a blank form, Revocable Living Trust. "This," she said, "is what you should have had from the beginning." She explained it slowly, methodically. A revocable living trust is a legal entity. You create it, you fund it, you control it while you're alive. But here's what makes it different from a joint account. Your children aren't owners, they're beneficiaries. That means when you die, they inherit. But while you're alive, they can't touch it. Their spouses can't claim it in a divorce. Their bad decisions can't erase your 31 years of work. The trust owns the money. You control the trust. And when you're gone, the trust distributes according to your instructions, not the state's, not a probate judge's, yours. Margaret asked the question she'd been holding since she walked in. Can they still take what's already in the joint accounts? Diane's face didn't change. That depends on how fast we move. Over the next 2 hours, Diane laid out the strategy. Step 1, remove Margaret's name from all 3 of her children's accounts, not by asking permission, by opening new accounts in their names only and transferring the funds, clean separation. Step 2, move Margaret's retirement savings into a new account. titled in the name of the trust, not Margaret Johnson, but the Margaret E. Johnson Revocable Trust, dated May 2015. Step 3. Execute a durable power of attorney for each of her children, so if they ever truly needed her help, hospital bills, emergency rent, something real, she could access their accounts without becoming an owner. Step 4. Fund the trust with everything that mattered: the retirement account, her car title, her small brokerage account, even the life insurance policy she'd been paying on for 20 years. Everything behind the wall, everything protected. Margaret's hands were shaking when she picked up the pen, not from fear, from something closer to rage. Rage at how simple this was, how available, how no one had ever told her. Not the bank representatives who opened those joint accounts, not the financial advisors who managed her 401k rollover, not even her own mother, because her mother had never known either. Diane slid the trust document across the desk. "This," she said, "is the paper that changes your position, Margaret. You're not a co-signer anymore. You're not a helper. You're not second on the list." She tapped the signature line. "You're the grantor, the trustee, the architect." Margaret signed. The pen was heavy, silver, the kind that required intention. The ink was permanent, and for the first time in 4 years, Margaret's name was in the right place. But there was still the matter of the summons, the divorce attorney who thought Margaret's retirement was part of the marital estate, the court date that was 3 weeks away. Diane closed the portfolio. Now we respond, not as a defendant, but a third-party claimant with superior title. Margaret looked up. "What does that mean?" Diane's smile was thin, professional, the kind of smile that comes before a courtroom. "It means we're about to teach someone the difference between joint access and separate property." Margaret walked out of that office with a leather folder under her arm. Inside, the signed trust document, 3 blank power of attorney forms, a checklist of every account that needed retitling, and a court filing that would be submitted the following Monday. The rain had stopped. The street outside was still wet, reflecting the late afternoon light like glass. Margaret stood on the sidewalk and took a breath. She wasn't safe yet, but she was no longer exposed. She had the paper now, the kind that builds walls. To be continued. What happens when Margaret's trust meets the courtroom? And what will her children say when they discover their mother is no longer on their accounts? The hearing was set for June 4th. Courtroom 3B, Durham County Courthouse, Family Law Division. Margaret arrived 30 minutes early wearing the navy suit she usually saved for funerals. Diane met her in the hallway outside, carrying a leather briefcase that looked like it had survived several decades of similar battles. "They're going to argue that your retirement account was accessible to your daughter during the marriage," Diane said. "That makes it marital property subject to distribution." Margaret's jaw tightened. "But it's not." "Correct, because 10 days ago you severed the joint ownership and retitled everything into your trust, which means as of May 25th, you are no longer a joint account holder. You are a separate legal entity." The courtroom was smaller than Margaret expected. Wood paneling, fluorescent lights, an American flag in the corner that had seen better administrations. Her daughter's ex-husband sat on the opposite side with his attorney, a man in his early 40s wearing a suit that cost more than Margaret's car payment. He didn't look at her. The judge was a black woman, late 60s, reading glasses on a chain, the Honorable Constance Murray. She reviewed the filings without expression, then looked up. "Counselor, you're claiming Mrs. Johnson's retirement account as part of the marital estate." The ex-husband's attorney stood. "Yes, Your Honor. Mrs. Johnson was listed as joint owner on multiple accounts held by the defendant during the marriage. North Carolina is an equitable distribution state. Joint assets are subject to division regardless of whose name appears first." Judge Murray turned to Diane. "Response?" Diane stood slowly. She opened the briefcase and removed 3 documents, placed them on the table in front of her with the precision of a surgeon arranging instruments. "Your Honor, Mrs. Johnson was never a party to this marriage. She was added to her daughter's checking account in 2011 as a safety measure, not as a co-owner with marital intent. Further, as of May 25th of this year, Mrs. Johnson formally severed all joint account relationships and retitled her assets into a revocable living trust." She slid the first document across to the bailiff. "This is the trust instrument, executed and notarized. The retirement account in question is no longer held in Mrs. Johnson's individual name. It is held by the Margaret E. Johnson Revocable Trust, a separate legal entity with no connection to the marriage or the marital estate." The opposing attorney's face changed. "Your Honor, this is clearly an attempt to shield assets from—" Judge Murray raised one hand. "Counselor, did your client ever contribute to Mrs. Johnson's retirement account?" "No, but—" "Did he ever have withdrawal rights?" "Not directly, but the joint account structure." "Did Mrs. Johnson ever receive any benefit from this marriage? Any income, any property, any claim?" Silence. Judge Murray removed her glasses. "Mrs. Johnson is a third party. She has provided documentation proving separate ownership and timely severance of any commingled accounts. This court has no jurisdiction over her trust." She looked at the opposing attorney. "Your motion is denied." The gavel came down once. Final. Margaret didn't move. She sat very still in that wooden chair, feeling the weight of 31 years settled back into her own hands. Diane leaned over and whispered, "That's called superior title. You own it. They don't. The court can't touch what it doesn't have authority over." Margaret nodded. She didn't trust herself to speak yet. Outside the courthouse, the sky was overcast but not raining. Margaret stood on the steps and looked at the folder Diane handed her. Inside, a certified copy of the court order, a letter to the 3 banks confirming the trust retitling, and a list of every remaining asset that still needed to be transferred. Her car title, her small life insurance policy, the savings bonds her mother had left her. Everything that mattered, everything that carried her name needed to move behind the wall. Diane walked her to the parking lot. "Now comes the harder part," she said. Margaret frowned. "What's harder than a courtroom?" Diane's expression softened just slightly. "Telling your children why their names aren't on your accounts anymore." Margaret had been avoiding that conversation for 2 weeks. She knew it was coming. She knew Marcus would be hurt, Terrence would be confused, Simone would feel blamed. But Diane had explained it carefully. This isn't about trust, Margaret. It's about structure. You can still help them. You can still be there in an emergency, but you're doing it the right way now, with a power of attorney that protects both of you." Margaret understood the logic, but logic doesn't make family dinners easier. That Sunday, she called all three of them to her house. She made her mother's pound cake, brewed a full pot of coffee, set out the good china. Then she sat them down at the kitchen table and told them the truth. She explained the joint accounts, the court summons, the attorney, the trust. She didn't apologize. She didn't ask permission. She simply stated what had been done and why. Marcus spoke first. "So you don't trust us anymore?" Margaret met his eyes. "I trust you with my life, baby, but I don't trust the world, and the world doesn't care about intention, it cares about paper." She slid 3 documents across the table, one for each of them. "These are powers of attorney. They give you the legal right to access my accounts if I'm ever sick or incapacitated. You can pay my bills, handle my affairs, make decisions on my behalf." She paused. "But my money stays mine, and your debts stay yours." Simone looked down at the paper. Her voice was quiet. "I'm sorry, Mama. I didn't know putting you on my account would—" "You didn't know because nobody told you, same way nobody told me." Margaret's hand covered her daughter's. "But now we know, and now we build different." That night, after her children left, Margaret sat alone in her study. The trust binder sat on her desk, navy blue with gold embossed lettering. She opened it, ran her finger down the first page. The Margaret E. Johnson Revocable Trust, grantor, trustee, beneficiary, her name first position every time. Outside, the grandfather clock in the hallway struck 9. Margaret closed the binder, placed it in the fireproof safe beside her bed, and locked the door. To be continued. The architecture was in place, but was the legacy secure? 3 years later, Margaret turned 56 in the spring of 2018. She retired that June. Not because she had to, because she could. The retirement account she had protected in that Durham courtroom had continued its quiet work. Compound interest, modest additions, time doing what time does when you give it structure. $89,000. Not a fortune by anyone's standards, but enough. Enough to stop setting an alarm, enough to say no without explanation, enough to sit on her porch in the mornings and drink coffee that was still hot, enough to not be a burden. Margaret had learned something in those 3 years, something her mother never got to learn. That protection isn't the same as hoarding, that boundaries aren't the same as rejection, that you can love your children completely and still keep your name in the first position. The trust had done exactly what Diane said it would. It had created walls, not to keep her children out, but to keep the world from reaching in. When Marcus went through his own divorce 2 years later, his ex-wife's attorney asked about Margaret's assets. The answer was simple. She has a revocable trust. It's a separate legal entity, not subject to division. Case closed. When Terrence needed help with a down payment on his first house, Margaret didn't co-sign the mortgage. She made a structured loan from the trust, documented, notarized, with repayment terms that protected both of them. He paid her back in 18 months. No resentment, no confusion, just clean paper. And Simone, the daughter whose divorce had started all of this, came to Margaret one afternoon in the fall of 2017. She brought her own legal pad, her own questions. "Mama," she said, "I want to set up a trust for the girls. Can you show me how you did yours?" Margaret smiled, not with her mouth, with her eyes. "I'll do better than that, baby. I'll take you to Diane." That's the thing about architecture. Once you see it, you can't unsee it. Once you build it, you teach others to build. And the walls you construct don't just protect you, they protect everyone who comes after. Margaret kept the trust binder in a fireproof safe beside her bed, but she kept a second copy in a sealed envelope in her kitchen drawer. On the front, in her mother's handwriting, salvaged from an old birthday card, she had written, "For my grandchildren, so they know their grandmother wasn't just kind, she was careful." Inside that envelope was more than just the trust document. There was a list. Every account, every asset, every beneficiary designation, the name of her attorney, the location of her will, the passwords to her financial accounts stored in a secure digital vault, instructions on how to access the trust after her death, instructions on how to avoid probate, instructions on how to keep the family wealth, modest as it was, inside the family. Margaret had also written a letter, 1 page, handwritten. It began, "By the time you read this, I'll be gone, but the paper remains. This is not inheritance by accident. This is inheritance by design." She explained the trust, the power of attorney, the beneficiary designations. She explained why their names were listed as beneficiaries, not owners. She explained what joint accounts had almost cost her, and she explained what structure had saved. The letter ended with one sentence. "You are not responsible for my decisions, but you are responsible for yours. Build accordingly." Margaret placed that envelope back in the drawer. Beside it, a small brass key to the safe and a note that said, "Open after I'm gone, not before." On her 56th birthday, her children threw her a small party. Nothing extravagant, just family, pound cake, her favorite jazz record playing low in the background. Terrence gave her a framed photo of the house he'd bought with the loan she'd structured. Marcus gave her a leather-bound journal with her initials embossed in gold. Simone gave her a copy of her own trust document, newly executed, properly notarized, beneficiaries clearly named. Margaret held that document for a long time. Then she looked at her daughter. "You did this right." Simone nodded. "I learned from the architect." That night, after everyone left, Margaret sat in her study. The same mahogany desk, the same rain-streaked window, the same quiet that had surrounded her during the hardest season of her life. But this time, the weight was different. Not the weight of fear, the weight of completion. Margaret opened the trust binder one last time, ran her finger across the embossed lettering. The Margaret E. Johnson Revocable Trust. She had built this, not with money, with paper. the kind that doesn't burn, doesn't fade, doesn't disappear when someone else makes a mistake, the kind that holds a name in place long after the voice is gone. Margaret closed the binder, placed it back in the safe, locked the door, and walked to the window. Outside, her small garden was beginning to bloom. Daffodils, azaleas, the dogwood tree her mother had planted 30 years ago. In the distance, she could hear her grandchildren playing in the yard next door, their laughter carried on the wind, free, protected, because someone had built the walls before the storm came. Margaret didn't know how many years she had left, but she knew this. When she was gone, her name would still be in the right position, and her children would know the difference between helping and exposing, between love and liability, between being kind and being careful. She had signed her own pivot, and the paper remained. It's time to stop being a guest in your own life and start being the architect. Sign your own pivot. Subscribe to the paper. Legacy is not what we leave behind. It is what we put in place. You have heard the story. You have seen the pivot. Now the drafting table is yours. If you are ready to move from equitable interest to legal sovereignty, join us in the vault. Secure the paper, protect the lineage. I am the asset architect, and this is the pivot paper.